literary or artistic work such as a film closer to you. So I think basically that's what you went through yesterday. Na-mention yesterday, I was listening and na-mention ni Yusek Josephine Maribohok that in the Constitution, it provides for what you call as a balancing of rights. So yung naunang provisions na binabanggit ko kanina are the provisions of the law on the protection of the exclusive right of the copyright holder or the creator or the author of a work. Okay? Ngayon naman, itong provisions na to under copyright law, under Chapter 8 of the Intellectual Property Code, are the limitations to copyright. Ito naman yung provisions that protect the right of the general public to access to information and to be able to enjoy literary and artistic works. So I'll proceed first with, this is a disclaimer, yung terminologies na gagamitin ko dito are our own terminologies just to simplify the principles for you. So I'll start off with what we call as general fair use principles. So general fair use principles, ano ba yung fair use? Yan muna ang sasagutin ko. Ang fair use, ang ibig sabihin ng fair use is even if you use or you exploited a particular work without the permission of the copyright holder, hindi pa rin siya matitreat as copyright infringement. Okay? I will repeat. Fair use says that the use of a work, even without the permission of the copyright owner or the copyright holder, is not considered as infringement if it complies with the general fair use principles. Okay, so it's contained in section 185.1. So the fair use of a copyrighted work, for what purpose? For criticism, for comment, for news reporting, for teaching, including limited number of copies for classroom use, for scholarship, for research, and for similar purposes is not an infringement of copyright. So although you don't have the permission, pag ang use of the copyrighted work are for any of the following: criticism, comment, news reporting, teaching that it's applicable for your particular case, scholarship, research, it is not considered as copyright infringement. Merong tinatawag na fair use factors under the same section of the copyright law. And you have 4 fair use factors. This is the first one being that the purpose and the character of the use. Bakit fair use factors? Pag may issue which we call as copyright infringement, may nagki-claim na na-violate yung kanyang copyright over a certain work, when it goes before the court of law, the judge, in determining whether there is fair use or whether there is indeed copyright infringement, will use these factors. So ang fair use factors are usually employed by the judge, but this can also be used prior to your work. Pag meron kang sinasite or meron kang ililift from a certain work, then it might be a good or prudent practice to also ask yourselves this: the purpose and the character of the use, including whether or not such is of a commercial nature or is for non-profit educational purposes. The nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or the value of the copyrighted work. Okay? So, lahat yan, when the courts of law determines whether there is fair use or not, hindi niya iniisa-isa yan. This works in tandem. So, ibig sabihin yan, i-consider niya yung particular case using all of these factors as a whole. Okay? So, nakita natin kanina ang possible purposes, which is number 1, are criticism, comment, news reporting, teaching, research, and for similar purposes. The term limited number of copies, because if you note, including limited number of copies for classroom use is not defined under jurisprudence or under the law. We believe that this is a matter for an implementing rules and regulations. And we are currently in the process of finalizing a draft implementing rules and regulations for this particular provision of the law. Okay. Then meron tayong tinatawag na, and this again, this is our term. This is our terminology. This is our typology. Meron tayong tinatawag na statutory fair use. Paano siya nagkakaiba doon sa general fair use principle? Sa general fair use principle, i-assess mo yung isang case on the basis of the factors mentioned. So it could come out as not fair use, or it could come out indeed as fair use. Sa statutory fair use, kung tawagin namin, ito ay mga specific situations which under the provision of section 184.1, sinasabi niya agad doon, pag ito ang sitwasyon, specific situations, walang copyright infringement. Doon sa isa, kailangan mo pang i-judge kung meron bang using the 4 factors whether or not there is fair use of a work. Dito sa statutory fair use, under section 184, because these are already specific situations, sinasabi agad ng batas na pag ito nag-fall siya under any of these, then walang copyright infringement. We would like to call them as statutory fair use. However, let me simplify again this provision of the law. So ang statutory fair use under section 184.1, enumeration A to L, okay, so that's 12 specific situations. Merong grupo dito na walang reference back to the general fair use principle. Ibig sabihin nito, makikita nyo later, walang na-mention na provided that it is consistent with fair use. Walang ganun na provision doon sa particular items na yon. Pero meron din mga provisions that refers back to the general fair use principle. Ano ang importance nito for you? Pag naandun siya sa first bullet, ang importante lang ay ma-meet yung conditions provided in that particular article. Pag naandun siya sa second bullet, then may caution. You will note later on, meron akong nalagay na green, meron akong nilagay na yellow doon sa provisions. Green means you only need to comply with the provisions of the law. Kasi either you complied with the provisions and therefore walang copyright infringement, or you didn't comply and meet the requirements of the provision, and therefore there is now copyright infringement. There is no fair use. Okay? I hope that's clear. So merong provisions dito na walang reference back to the general fair use principle. Makikita nyo yan later on as green. Yung pangalawa naman, there is a reference back to the general fair use principle. So ang kinolor ko dyan ay yellow. So parang sa stoplight. So medyo mag-caution kayo if the basis for copying or using a copyrighted work would be under bullet 2. Pag bullet 1, you just need to determine na-comply ko ba yung requirements ng particular article na yan. Let's go to the first set ng bullets. Okay. Ito yung walang reference back to the general fair use principle. Okay. So ito, ang tawag dito, just to simplify, I know you can read this. Just to simplify, ang tinatawag dito ay private performance. So the recitation or performance of a work, once it has been lawfully made accessible to the public, if done privately and free of charge, etc. So private performance is a statutory fair use. So pag hindi siya private performance, then kabahan ka. You cannot use this as a defense for the use of a work without the permission of the copyright owner. So, nandun siya sa 184.1. The next one is reproduction or communication to the public by a mass media of articles on current political, social, economic, scientific, or religious topic for information purposes and for information purposes unless it has been expressly reserved. Okay? Unless it has been expressly reserved. So ito, I think, tinitingnan ko to kagabi, and for the purpose of DepEd personnel, especially in the Bureau of Learning Resources, I think more or less hindi ito magiging applicable sa this will not be available for your particular use. Kasi itong pangalawa should be ang user, ang nag-reproduce dapat is a mass media entity. So ito na, 184.1 D and F are examples of statutory fair use that may be applicable. I say maybe kasi kayo na, I will leave it to you guys to determine whether or not it falls under your particular use of a copyrighted work. The reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events by means of photography, cinematography, or broadcasting to the extent necessary for the purpose. While it may not be applicable to DepEd for its learning materials, baka applicable to for some schools. So I know that there are yung mga legal ng districts and the provincial offices here for some activities of the schools where there is a reproduction or communication to the public of literary or artistic works as part of reports of current events. So hindi siya applicable in general, but there may be various activities or school occasions where this particular provision may be used to justify the reproduction or communication to the public of a copyrighted literary, scientific, or artistic work. And the next one, and I think naka-green yan, okay? Because this is applicable to DepEd in general, the recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions. Okay. So under this section, the recordings must be made by any person duly authorized by the school. It must be made in schools, universities, or educational institutions, not outside of it. It must be used for the use of such schools, universities, or educational institutions. It must be deleted. Incomplete actually yung nilagay ko dyan. May dalawang proviso may dalawang provided that, may ganon ang batas, meron siyang dalawang proviso for this particular section. And I read to you the provisos. The first one is that such recording must be deleted within a reasonable period after they were first broadcast. Okay. So ni-record mo siya. Pero sinasabi nito, for it to qualify as a statutory fair use, it must be deleted within a reasonable period of time. What is reasonable? We'll put that in the implementing rules and regulations, which of course we invite also the Department of Education, especially the Legal Affairs Group, to comment and make known their inputs to this particular draft of the implementing rules and regulations. So walang nakalagay sa batas kung ano yung reasonable, but will advance a certain period which will be treated as reasonable period within which dapat yung recording must be deleted. And the next proviso, sabi dito, provided further that such recording may not be made from audiovisual works which are part of the general cinema repertoire of feature films. So ibig sabihin, hindi mo pwedeng ipalabas ng buo ang isang commercial film except, sabi dito, for brief excerpts of the work. So pag brief excerpts of the work, pwede for recordings made in schools, universities, etc., etc. But not the entire film or work which is part of the general cinema repertoire of feature films. So kung meron ka lang gustong i-point out if you're teaching acting classes for a particular subject, then you may put in excerpts of a particular audiovisual work or a feature film, but not the entirety of it can be shown. So, just to go back, yung isa yellow, yung isa green. Then G, ephemeral recordings. This is also not applicable to you, so I'll quickly go through it because this is applicable to broadcasting organizations. Ephemeral recordings, parang yung letter F nyo, meron ding period dapat na tinatanggal agad yon. Example, nagkaroon siya ng broadcast, doon sa background ng broadcast, merong literary or artistic work, such as a painting, or a particular music being played. So yon, pag incidental lang siya in an ephemeral broadcast, okay lang yon, provided it is now deleted after a certain period. Then the other one, letter I, is also, I mark this also as yellow because it may be applicable to certain school situations. It may be applicable to certain school situation, but it is not applicable, I think, for purposes of your learning materials. Baka meron lang dito, I know kasi there are lawyers here in the group of the divisions and the provincial offices. Ito can also be applicable to certain school situations. Public performance, basta in a place, no admission fee is charged, in respect of which it is used for charitable or educational purposes and by a club or an institution. Again, J, I mark it as yellow because this may also apply to certain school activities which uses the display of the original or a copy of the work not made by means of a film, slide, television, image, or otherwise on screen or by means of any other device or process. So ito not for BLR, not for learning materials, but this will be applicable to certain situations. Then K is for judicial proceedings or for the giving of advice by a legal practitioner, not applicable. Well, this can be applicable for those working in your legal office, for your legal affairs, if that's what you call your particular office. Next, the reproduction or distribution of published articles or materials in a specialized format exclusively for the use of the blind, visually, and reading impaired persons. Etong addition na to is a recent addition to the law. It was added in 2013 under Republic Act 10372. Kasama kasi ito sa or compliance ito sa Marrakesh Treaty. If you've heard of the term Marrakesh Treaty, ito yon, which benefits the blind, visual, and reading impaired sector of your student population. So ano ang mangyayari dito? Sabi dito, pwedeng mag-convert. You can now convert a published material into a format such as Braille, which is accessible format copy for purposes of the blind, visually impaired, and reading impaired persons. So, si DepEd just recently through the Office of USEC Maribuhok has sought confirmation of na ang DepEd is authorized to under this particular provision 184.1L, and we confirm that DepEd, being a government institution in charge of educational purposes, wherein part of its student population are the blind, visually, and reading impaired persons, kasi pwede siyang mag-convert ng work into an accessible format copy. Let me just note that there are certain conditions, nevertheless, that are required under 2019 IPOFIL Memorandum Circular number 2019-025. This is available for downloading in our website at www.ipofil.gov.ph. And that first condition is that yung pagkokopyahan, di ba, ita-transform mo siya into an accessible format copy. So the original material on which you will base the transformation must be legally obtained. So it must be legally obtained. Hindi pwedeng nag-download ka ng pirated copy online and then you transform it now, because then that would be a violation even under 184.1L, because it says, and that was clarified under the circular, that yung source work must be something that has been obtained legally. So dyan nagtatapos yung first bullet. Ito yung mga sections of 184.1 na walang reference back to the fair use principle. Walang reference back to the general fair use principle. There are a remaining, kung mapapansin nyo, may mga sections na nawala, like B, because they fall under the second bullet. Meron siyang reference to fair use principle. Okay? The first one is, and this is applicable to you, and I put there yellow because this should provide you caution. Totoo, statutory fair use ang making of quotations from published work. However, they must be compatible with fair use and only to the extent justified for the purpose, etc. Okay. Making of quotations. So, pag quotation lang pala, okay. Hindi ka kailangang kabahan. Even, take note, ang requirement is that it must be from a published work. Because pag nag-quote ka from an unpublished work, you actually violate the author's right to the first public distribution of his work. siya lang ang may karapatan, yung author lang ang may karapatan na unang mag-publish ng kanyang work if it is still unpublished. So the making of quotations is statutory fair use from published work. However, they must be compatible with fair use. Ano ba yung sinasabing ng factors kanina? It must be such that hindi naman siya kinopya mo na yung buong book. Essentially, nag-leave out ka lang ng mga certain parts, but every now and then you are making quotations of the entire book. Okay? Then, or an entire material. That is not compatible with fair use. So, naka-yellow siya because, yes, it's fair use, but then again, you have to assess, is the making of quotations only to such amount that it is justified for the purpose of which I'm making the use. So for example, gusto mo lang there is a particular quotation from a reference material that is applicable for a chapter heading. Etong chapter na kasi na to talks about something at very applicable yung sinasabi ng isang author. Then you can make that quotation, but don't make make quotations of such amount na halos practically kinopya mo na rin yung buong article or yung buong essay or yung buong reference material na pinagkopyahan mo. The next one, the inclusion of a work in a publication, broadcast, or other communication to the public, sound recording or film, if such inclusion is only by way of illustration for teaching purposes. And again, there is the requirement that it must be compatible with fair use. Illustration for teaching purposes. So kung ano lang ang kailangan mo na amount to illustrate a certain point, then that's the only amount that you need to include in your film or sound recording in order to illustrate a certain principle or a certain aspect. H, and this is, I think, the last one for statutory fair use. The use made of a government, the DepEd people led by Director Orebia are listening. This one is a powerful provision of one of the law on limitations and to copyright. The use made of a work by or under the direction or control of the government, the National Library, or by educational, scientific, or professional institutions. Pero meron pa rin siyang sinasabi dyan. Ang conditions niya is such use must be for the public interest. And again, you reference it back to fair use principle under 185.1. Okay, so I think this one is applicable to you. Naka-yellow siya. I did not put it green because there is a reference to fair use and therefore fair warning. You still need to assess. And I think that is a matter of policy or is a matter for your quality assurance, QA yata ang tawag nila doon, to note that not so much has been copied, even if it's for the use by DepEd, such that it will no longer be treated as compatible with fair use. Kasi kailangan din natin, in a way, protektahan yung karapatan ng exclusive owner of the copyright. But at the same time, for public interest and in order to fulfill the constitutional mandate na dapat accessible din ang information as well as ma-enjoy dapat ng greater majority of the public ang literary and artistic work, meron silang nilagay sa batas na fair use guidelines. There are other provisions. Private copying, this is one of the questions which we asked to be filled in by the participants. Private copying. Is private copying allowed? Yes, single copy. should be made by a natural person, not a juridical person. It's exclusively for research and private study. And subject, ito ang madalas makalimutan, even from among lawyers like me. Okay? Na ang batas pala, may nilagay siya dyan na subject to the provisions or limitations under 187.2. Ano yung isa sa mga limitations under 187.2? An entire book cannot be copied even if it is for research and private study. I know hindi rational, but at the moment, it is the provision of the law. This is something that can be perhaps a subject of amendment to the legislation, but at the moment, it is part of the limitation to private copying as an exception to copyright. So kahit na exclusively for research and private study, you cannot copy an entire book or a substantial portion of it. So alam nyo na yung sagot doon sa isang question. Is it okay for private study to copy an entire book? No. It is still a violation of the Intellectual Property Code, in particular the law on copyright. Should we break or should I continue? I can continue. This is a few slides na lang. Jejo or Attorney Shoson?
Yes, sir. If you want to continue, sir, yeah, I guess you can continue if it's just a few slides.
Okay. Sige. So, meron ng fair use, meron na ring mga karapatan na ni-lecture kahapon at ni-recall natin kaninang during the first part of my presentation. Now, let's go to what you call as copyright infringement. What is copyright infringement? Copyright infringement is whenever a person, whether juridical or natural, violates any of the exclusive rights. Kaya inulit ko ulit yung exclusive rights eh. The right of reproduction, the right of transformation or translation or adaptation, the right of rental, first public distribution, public performance, saka communication to the public. So whenever a person violates the right of another, isa sa mga pito na yon. Let's say for example, he reproduced a book, own or essay na lang, lagi na lang book. He reproduced or copied an essay by another without the permission of that copyright owner, then you call that copyright infringement. So whenever a person violates any of the exclusive economic rights of the copyright holder, he commits what you call as copyright infringement. This is provided for the lawyers in the group again in section 216 of part 4 of the Intellectual Property Code. So may tatlong klase ng infringement by which infringement is committed. Yung unang bullet is called direct infringement. So siya ay mismo yung nag-photocopy ng book. That's direct infringement. The second one is what you call as vicarious infringement. So ito, whenever somebody else benefits from an infringing activity of another person who commits an infringement, nakinabang siya. So, siya yung nagbasa nung finotocopy na entire book nung isa. And therefore, he benefited from it. He committed vicarious infringement. And the last one is what we call as contributory infringement. With the knowledge of an infringing activity, you induce, cause, or materially contribute to the infringing act of another. Siya ang nagbayad nung cost of photocopying the entire book, then that's contributory infringement. So ang liable for copyright infringement are not only those who directly commit an infringement, but those who benefit, vicarious, or who contribute, contributory infringers. So may direct infringer, may vicarious infringer, meron din contributory infringer. Ano ang penalties? Section 217, first offense, 1 to 3, 3 to 6, 6 to 9. That's the imprisonment terms. First offense, 1 to 3 years. Second offense, 3 to 6 years. Third offense and subsequent offenses, 6 years and 1 day to 9 years. The fine, it ranges, as you see in this table, from 50,000 to 1.5 million. I'll go to the last portion. What do you see on screen? Because you are educators, I know you are very familiar with this particular type. It's called the Venn diagram. And essentially what a Venn diagram illustrates is ito, yung nasa gitna, yung overlap between one of the circles to that of another. So, sabi ko dito, yan ang pagpe-present natin ng copyright infringement at plagiarism. I copied this. I saw this in the presentation of Attorney Louis, and I think it's a good representation of the difference between infringement and plagiarism. So the question is copyright infringement the same as plagiarism? The answer is no. They are two separate concepts. There are, however, instances where plagiarism is also constitutes copyright infringement, and there are occasions also when copyright infringement constitutes plagiarism. So sabi ko dyan, it's note, not all copyright infringement is plagiarism, and not all plagiarism is copyright infringement. Ano nga ba ang plagiarism? I defined earlier already what copyright infringement is. Let's go to plagiarism. Plagiarism, according to Black's Law Dictionary, is the deliberate and knowing presentation of another person's original ideas or creative expressions as one's own. Importante tong definition na to. Deliberate and knowing presentation of another person's original ideas as one's own. So in other words, ni-represent mo na ang isang work ay sa'yo. An original idea or creative idea when in creative expression, when in fact, it belongs to another person. It is the idea or the creative expression of another person. So, ideas, ni-lecture sa inyo ni Attorney Bayaras yesterday that ideas are not protectable by copyright. Ideas are not protected by copyright. So what are protected by copyright? It's the expression of these ideas, the creative expression. So take note, ang plagiarism concerns both ideas as well as creative expressions. Ang copyright infringement, because copyright infringement means there is copyright to start off. So, is involved only in creative expressions. So ideas are not copyrightable, and therefore, the copying of ideas is not the subject of copyright infringement. Only the creative expressions of those ideas are subject to copyright protection. So, ano nga ba ang pinagkaiba? The table here provides, in short, a gist of the difference between copyright infringement and plagiarism. Copyright infringement is provided in the IP code. It's in section 216. Plagiarism is not provided for in the IP code. The closest provision of the law to refer to plagiarism is the violation of an author's moral right of attribution. Diba sabi natin doon, one of the moral rights of the copyright of the author or the copyright holder is that he be attributed as the author of the work, which he is the owner of. So that's the closest provision under the IP code that somehow refers to plagiarism. But plagiarism, the concept itself is not provided in the IP code. Copyright infringement is more of a legal construct. Construct meaning mas usapin siya ng legalidad. Pag ang pinag-uusapan ay copyright infringement. Pag plagiarism, it's more an ethical construct. And therefore, tama at mali ang pinag-uusapan dito. Na hindi nga naman tama na akuin mo bilang sayo ang isang work or an idea which is not yours, really. So it's more of an ethical construct. Copyright infringement is committed only where copyright subsists. Pag walang copyright, such as when the work is in the public domain, then no copyright infringement can be made because the work is already in the public domain. So for there to be a violation called copyright infringement, copyright must subsist, and that somebody is the owner of the copyright to that work. So plagiarism, even when there is no copyright, it may still be committed. Okay? Copyright infringement, the offended party, and I'm using the word offense lightly here, not in the legal sense. Copyright holder, ang aggrieved or offended party is the copyright holder. Kasi siya nga ang may exclusive right to exercise any of the 7 rights that we mentioned earlier. Plagiarism, who is offended? It's the community at large. Why? You represent, nilinlang mo sila. May panlilinlang na naganap because you represented something as your work when in fact it's not your work. And I'm down to my last slide, which is a short exercise on the difference between plagiarism and infringement. Let's go to the first dapat i-email ko to kanina para menti.com din. Pero let's just answer it and you follow with me. Mr. A photocopied an entire book. How do we answer this? You first find out whether copyright subsists. Is the book an old book? More than 50 years nang patay yung author? Then, it's now in the public domain. Let's say copyright subsists. You photocopied the entire book for private study. Is there copyright violation? Yes. Kasi meron pang copyright doon sa book na yon. What if if it's already in the public domain? Is there a violation? Wala na. Walang copyright infringement. Is there plagiarism? No, because you photocopied the book. You did not represent it as your own work. Next. Miss B retyped an article appearing in a provincial magazine. Dahil provincial magazine, akala niya hindi na malalaman at matitrace. Placed her name as author thereof and submitted it to a local magazine in Metro Manila for publication. Is there copyright infringement? Depende kung meron pang copyright doon sa article appearing in the magazine. Assuming there is there copyright still subsists, then there is copyright infringement. Assuming there is no copyright anymore in the article, then there is no copyright infringement. Is there plagiarism? Even if there is no copyright in the work and there is no copyright infringement committed, there is still plagiarism. Why? You presented as your own the work of another. Next. Mr. C reproduced an essay from a well-known essayist who died 55 years prior and represented it as his own. So, this is an example of a work that is now in the public domain. Okay, so there is no copyright infringement because it's now in the public domain. There is still, however, a violation for plagiarism. Example, Shakespeare. You can quote Shakespeare, but do not put it as your own quote. Why? Even if there is no more copyright there in the work of Shakespeare, then still you represented it as your own, which is the essence nga of plagiarism. Miss D took the idea of her mortal enemy and made a short story out of it. Again, papasok tayo dito sa idea-expression dichotomy. Copyright protects only the artistic expression, the creative expression, and not the idea. So copying the idea of another may qualify as plagiarism, but does not qualify as copyright infringement. On that basis, I think we have time for question and answer. Thank you very much. I forgot to thank again DepEd, sina Attorney Orebia, Director Orebia, Yusek Maribuhok, and Attorney Shoson for giving the IPOFIL, in particular the Bureau of Copyright, the opportunity to touch base and to share our knowledge on copyright with the personnel of DepEd. On that note, I thank you very much for listening, and maybe we have time for question and answer.
Thank you, Director Cuyo. Maybe siguro po we'll give Director Cuyo some time to rest, a little time to rest, and then we will start with some of the questions that you have been posting since yesterday. Again, we thank you, the IPOFIL, as represented by Director Cuyo, for participating in this event. They have been very helpful in providing so much information for us, and I hope some of the questions already that were posted yesterday have also been answered already by the presentation of Director Cuyo. And again, we thank you all the participants for submitting your questions yesterday and today. And that while we cannot acknowledge all of you individually, we have taken note of some of your questions, and there are a lot of questions actually regarding copyright limitations and exceptions. Especially, I believe this is especially used kasi po by teachers in the classroom. As I used to be a teacher myself, before becoming a lawyer, nagturo rin po ako sa grade school, and naranasan ko rin pong gumawa ng mga modules for children. So I know mahirap po siya talagang task, hindi po siya madaling gawin, hindi po madaling maging content creator. So I hope that with the presentation of Director Cuyo, na-enlighten po tayo na meron po tayong pwedeng gawin, meron po tayong pwedeng gamitin, na pwede po tayong gumamit ng copyrighted materials under certain conditions. that yun nga po, it has to be compatible with fair use, and it has to be, and for some instances, there are copyright limitations that we can use. Sana po ay naintindihan po natin ito sa presentation po ni Director Cuyo. Director Cuyo, if you're ready for some of the questions,
Yeah,
may we
sure.
ask them?
Fire away. Yes.
Some of the questions, most of the questions would the participants are asking for specific examples po of what would be considered as fair use. For example, you mentioned that for fair use factors, yung sa general fair use, they are not considered in tandem. Even, would that mean even for magkaroon lang na one factor, it could be a ground for copyright infringement?
No, I'm sorry if that was the impression, but I said that everything is taken in tandem.
Yes, sir. But what I mean is, how does all the factors have to be present? Does the four factors have to be considered?
Yes, all factors will have to be considered in its totality.
Thank you, sir. And as I said, the participants are asking for
an example. Yes.
Yes, yes. Yes, sir.
An example is the nature and substantiality of the amount copied. That's one of the factors, di ba? And its effect. So kahit na substantial yung kinopya in certain cases, for example, but it find out doon sa pag-assess ng court, walang naging epekto, for example, sa market value or potential market of the work. Kasi makikita mo na magkaiba pa rin siya. Then, the court will now consider this in its totality and rule on whether or not there is fair use or there is copyright infringement. So hindi siya isa-isa na ito pumasa ka to, check. Then therefore there is copyright infringement. So pwedeng check ka sa isa, but in its totality, because there are four factors to be considered, in the end the court might rule that still fair use.
Thank you, sir. Thank you, sir, for that answer. And another question relates to giving a specific example po. Although I believe some of our lawyers already know the answer to this, but for the clarity lang po of our other participants who are non-lawyers, yung paggamit po ng YouTube, for example, sa pagtuturo sa classroom, would this be considered fair use or within copyright limitations and exceptions po?
Paggamit ng YouTube.
For example po, nagturo po siya sa loob ng classroom, gumamit po siya ng video from YouTube. Is this considered within the scope po of our copyright limitations?
I'll have to take a look at that. YouTube. So, ibig sabihin ang audience nito is the public in general?
No, sir. It's in the classroom. It's within the classroom setting.
So, nag-play siya ng YouTube video?
Yes, sir.
Okay. Then I think that would that would fall under classroom use. And anyways, there are various methods na rin naman na ginagamit ang YouTube by which the copyright owner of the work is compensated. Na-monetize naman yon. So I think YouTube covers that, the use of it.
Thank you, sir. Thank you, sir. Thank you for that answer. And also another question posed by one of our participants is, for example, this is from, I believe probably a SPED teacher, special education teacher. What if kumuha po siya ng video and naglagay siya ng sign language, like it's the same video, naglagay po siya, but nag-insert po siya ng sign language, are there copyright implications to this?
Video, nag-insert siya ng sign language. Hindi kanya ang video, syempre. And then, use it as a material?
Yes, sir, for teaching, of course.
Okay. Hirap to. Because there is such a thing as you call translation, and the owner of that particular right of translation or adaptation is only the copyright holder. So pag may prohibition doon, yon, then I think there will be copyright infringement depending on the terms by which the particular video na translate into a sign language is published. Tama ba yung pagkakasabi ko? Depende kung ano ang conditions ng original video, because translating it into a sign language would be a derivative work. However, with the use of the particular video, dapat meron pa rin siyang pahintulot from the owner of the video, the copyright holder. Split video from if it's a split, even if it's a split video, because the owner of the copyrighted work or the original video has the right to against the right of transformation and adaptation, as you call it. Ito yung number 2 right niya under exclusive rights. So karapatan niya na ipagbawal na i-translate yung work niya kung ayaw niya talagang ma-translate yung work niya. So that's why my answer is that it would depend on what the conditions were specified by the owner of the original video. Pero merong mga instances, for example, na ina-allow naman niya, then translating, there is an implied permission from the owner of the copyrighted work, then okay lang yon. But if not, then there is, I think, a violation of copyright.
Thank you, sir, for that clarification. I believe that also includes other online materials, like I believe the Creative Commons, I believe, is also included in that kind of materials. What are your thoughts on these kinds of materials online?
Yes,
mga Creative Commons po.
Okay. When you go to available resource materials on the internet, papansinin nyo, madami kasi sa atin hindi na binabasa, no, yung conditions. But when you click on a video, there are usually portions there that would tell you what the copyrighted character of the work, whether it's copyrighted, it's free for everyone to use, it's free under certain conditions, etc. So I think, especially for those using it for their learning materials, tingnan po natin yung portions na to in the videos, in the pictures, in the images, or in the drawings that we have. Kasi naandin din po nakalagay. Okay. So, pumunta tayo sa tinatawag nila na Creative Commons. Ang Creative Commons, just to debunk the notion that there is no copyright there, there is actually a copyright in your Creative Commons kasi identified naman kung sino yung may-ari ng work. Like for example, photographs, yan. Photographs, identified naman kung sino yung creator or yung photographer or the author of the work. However, under Creative Commons kasi, it's called royalty free. Hindi ka sinisingil for use of the work. But sometimes, even Creative Commons would give certain terms and conditions for the for the use of the work by others. So in other words, pag Creative Commons, mas free ang paggamit ng work. Hindi totoo na walang copyright doon. Meron pa rin copyright doon, kaya lang hindi ka sinisingil at hindi masyadong mahigpit ang pagbawal sa'yo na gamitin yung work. So usually doon, pag titingnan nyo in the free sources that you have, you would note na meron pa rin silang requirement na i-cite mo. Pag kinopya mo yung picture from a free source or open source, kailangan mong i-cite pa rin yung, meron doon minsan pag click on this to cite this particular photo if you're going to use it. So that's called the term of the license. Meron pa ring license doon, binibigyan kayo ng pahintulot to use the work and you are not collected a royalty. So Creative Commons, these are open source, it's free for everybody, but let's be careful lang as to its particular use. And second, let's also be careful about the time of the particular use. Kasi pwedeng ngayon na andun siya sa Creative Commons, pero inassume mo lang na dahil nakopya mo na siya dati, kokopyahin mo rin lang din ulit. Pwedeng ngayon, meron na siya, naglagay na siya ng limitation to it. So let's counter check again whenever you've used a material from these sources, whether or not it still does exist. So I think that's my answer to your particular question.
Thank you very much, Director Cuyo. And another specific question that we received from our participants is, meron po bang copyright implications if the teacher or illustrator copies a image, a picture, tapos it's hand-drawn by him na? Meaning, ginawa niyang basis yung isang actual picture or illustration and he drew it again himself. Would that be still considered a copied version, or is it now a material that's original to him?
Well, in the Philippines, wala pang jurisprudence on that. So I think I would answer more not as a position of the Bureau, but in my personal assessment. Pag ganon, depende kung ang kinopya niya are the essential or copyrighted factors of the photo. Pag kinopya niya, even if translate niya from a picture ginawa niyang drawing, there may still be a violation of the right of the photographer. So it will have to be ruled on a case-by-case basis kasi right now I cannot make a general categorization na dahil transform niya into an artwork, then walang copyright infringement. Kasi kahit na nag-transform siya into an artwork, remember, as a derivative work, magiging derivative work kasi yan, you should not hijack. In a derivative work, you should still not hijack the rights of the original, of the owner in the original copyrighted work. So I cannot make a definitive stand na yes or no. It will have to depend on the specifics of each case. Kasi pwedeng ang nakopya niya is the essential element of such that kopyang-kopya na niya talaga. So parang na-transform lang into yung final product. Pero that may still constitute copyright infringement. Kasi di ba sa derivative work, for it to qualify as a new work, di ba sabi natin protected by siya by copyright, dapat although nakaderive siya from an original work, dapat meron kang creative expression pa rin na in-input doon sa bagong work. And therefore, ang pinoprotektahan na derivative work are the elements which are your new additions in addition to the original work. Parang ganun ang mangyayari. Your creative expression in the new work, yung elements niya na wala doon sa original work, yun ay yun yung magiging copyrighted. But the copyright in the original work still remains. So my answer there is, if the drawing or artwork substantially copies the copyrightable elements of the photo, then I don't think that would be I think that would be a violation already of the copyright, the rights of the copyright holder.
Thank you po, Director Kuyo. So it's more or less it's case to case, depende po sa
Yes.
situation. Director Kuyo, I believe we have also Ma'am Bessie Agamata of the BLR who wants to ask you certain questions. Would that be okay? Si Ma'am Bessie, can we have her here now? If she has questions to ask Director Kuyo. You can take a breather muna po, Director Kuyo, while we ask Ma'am Bessie of BLR to also appear with us. Anyway, while we're waiting for Ma'am Bessie of BLR.
Yeah.
There's Ma'am Bessie now.
Yeah, hello.
Hi.
So,
Hello.
Good afternoon, sir. Good afternoon. Wait, I lost the question. All right, actually, this came from one of the participants. So, the question here is that she's a SPED teacher, all right, handing deaf and hard of hearing learners in a self-contained setup. Hindi daw po niya kasi, what is this? What do you call that? Na-mention ata sa statutory fair use 184 ang reproduction and distribution of materials for the learners like the students who are hard of hearing. Can we still make or produce reading materials with sign language so our learners can surely understand the printed materials even when they just staying at home?
Yes. Yes. Yung section L is only for the blind, visually impaired, and reading impaired persons. Unfortunately, the law does not include as a fair use exception the conversion of materials for our hearing sector. Hearing yung tinatawag nila doon na hearing sector. We are in touch actually with that particular sector to know and to study for ourselves together with them kung ano ang pwede nilang gamitin na provision of law, or there is a need to put it in a mandatory portion of the law. So yes, totoo, wala siya. So is it safe to just convert one into an FSL? I think at this point it is better to have the permission of the work which needs to be transformed.
So another, sir, last lang kasi actually this is one of the questions perennially asked from us. If one deliberately used a PowerPoint presentation of someone, can that be considered as plagiarism?
Deliberately use that assumes na walang permission?
I think so, sir. It was mentioned here.
It's not plagiarism if for all intents and purposes there is no representation na kanya yon. For as long as ginamit niya na, let's example, my presentation, if you just remove my name and then represent it as your own, then merong plagiarism yon, because that's the essence of plagiarism. However, there might be copyright infringement because yung presentations nyo are copyrightable subject matters.
Okay, so thank you, sir.
Thank you.
Sir, may we still ask a few more questions?
Yes.
With regards to, sir, the government work also, copyright and government work, we'd like to clarify, sir, if you mentioned there's regular assigned duties. If if government work, for example, sir, is to develop learning materials, and it's a regularly assigned duty, the owner of the copyright would be, if it's government work, it would then be the government. Is that correct, sir?
Yes.
Except if there's an agreement, right, sir? Is that correct?
If there's yes, if there's an agreement, part of his regularly assigned duties, yes, it belongs to the government, and then except when there's an agreement to the contrary.
Yes, sir. Then there's also this other aspect. If it's not his regularly assigned work, if it's commissioned work, then there should be a written agreement.
Yes, a written stipulation.
What would suffice, sir, as a written agreement, so that we may be clarified on this matter? What would suffice?
It may be as simple as if you wala namang requirement yung law, so it can be a simple agreement. Kasunduan may be written in layman's term for as long as it is clarified there that the creator, because that's the provision of law, that the creator retains the ownership of the copyright. So if there is now a written agreement, kasunduan between the commissioner and the creator of the work, na pinapasa na niya totally en toto lahat, not only the physical work but the copyright in the work, then yun lang, just simple statement that I am transferring or ceding my copyright in this work and all related rights there to this particular person. Pwede kasing take note that when you do an assignment or transfer, and even in fact when you license somebody, pwedeng exclusive, so lahat yon, or pwedeng iba-iba yung tao. So basta very clear doon sa agreement ano yung tina-transfer niya. Remember, hindi pwedeng copyright lang siguro to. There must be clarity kung lahat yun, yung buong exclusive rights niya, ang tina-transfer niya, or certain aspects lang, like for example, rental or public performance of his work. So all others, i-retain niya for himself. Again, hindi yan prohibited sa law, and therefore you can enter into any combination of stipulations basta klaro ano yung tina-transfer ng one party to another.
Thank you, sir, for that that answer, for that clarification. And we also have, sir, a follow-up question regards to government work. Our question is that if for example, government work is there's no copyright that subsists in government work. So, yes. However, government can be assigned copyright. Is that correct, sir?
Yes, can be the recipient of a copyright.
But when this copyright is assigned, sir, does the government retain then the copyright? Does the copyright now subsist, or it loses its copyright?
No, ganito yan. Si government, pagdating sa works niya, okay, of the government, walang copyright na nagsubsist doon. There is no copyright in government works. However, when it's a third person's, so for example, an individual, ako na lang, I have a copyright in a work which I assign to the government will now have copyright. Because ang pinag-umpisahan nun is not a government work. It's a work of mine, and therefore, as creator, I have the copyright there, and then I assigned or transferred the copyright there to the government. So sa batas, pwedeng maging recipient ang copyright ang government at magkakaroon ng copyright. In fact, pwede siyang mag-sue for infringement, pwede siyang mag-collect ng license over the use of the work yung government. So wala lang copyright ang government when it comes to copyright when it comes to its own work. But somebody can give parang it's like a property na ita-transfer sa government because this is intellectual property. So pwedeng i-transfer sa government and now para na siyang copyright holder.
Thank you, sir, for that clarification. Medyo even us lawyers are confused, sir, with regards to the provisions kasi on copyright and government work. So thank you very much for that clarification.
On that note, we have one IRR coming out on government works, copyright for government in general.
Thank you, sir. We look forward to seeing that IRR. Sir, related to that also, if, for example, DepEd, we are a government agency and we use materials, images from another government agency, do we need to ask their permission? Because there was one question fielded here that she, for example, wants to use material from the KWF, Komisyon ng Wikang Filipino, and would now she be required to ask permission since this is another government agency?
In the IRR, there are situations where no permission is required. So from agency to agency, generally no permission is required, exception when it is used now for commercial purposes. I think that's the exception there, where even if it's another agency and even if there is no copyright in the work, there is still under the provisions of the law requirement for them to ask permission. Let me just confer with my CODAL whether what particular provision. Yeah, there. Yeah. So ang government to government general rule wala unless it's required for commercial purposes. So may commercial exploitation dito and therefore it's just ethical also that you ask permission from the agency which produced the work.
Thank you po, sir. Director Kuya, I think Director Orebia of Legal Service is here also now to ask certain questions. Would that be okay, sir?
Yes po. Hi, Director.
Emerson. Actually, I just like to share. nga po nakapasok din. We just like to share with you some questions from our participants, and we do appreciate them really sending these questions because we can feel what do they do in the field, especially the schools. Kaya kung okay lang po na we also add some questions pa po. And if ever these were already covered earlier by Attorney Arta or Ma'am Bessie, I can just read another questions again po.
Sige po. Sige. Yes, ma'am.
If a video is taken of a teacher teaching a lesson from a book and flashes on the screen parts of the book, then uploads the video to the internet, what are the copyright implications? I'll read again. Okay na po ba?
Sige, hindi. Sige. Pakiulit.
If a video is taken of a teacher teaching a lesson from a book and flashes on the screen parts of the book, then uploads the video to the internet, what are the copyright implications?
So a third person videos the teacher teaching a lesson from the internet. So may transformation na to ng rights eh. So ang importante dito is yung video that was uploaded on the internet. I think the implications are well, video niya yon. I think there may be laws, other laws that may be violated. In particular, kasi hindi naman to, wait. No, it's not considered as a performance yung teaching. So I'm thinking kasi if it's a performance, normally there are copyright implications. But the teaching itself and the video taking thereof, baka ang problem. Who owns the video? Hindi. Am I correct? The situation is there's a person who videotaped a teacher teaching na yung lesson niya is from a book. Okay? Is that the situation? And then the person who took the video uploaded it on the internet. Tama ba? Hello?
Yes, that can be a situation po. Or another one, like another one is taking the video from a teacher na teaching and then siya ang nag-upload. Then another possible interpretation of this is related to the teacher using contents of the book and then teaching it and then binidyo siya kahit na siya ang nag-video herself and then in-upload sa YouTube. Siguro it's like free use din po ba ito or derivation din po ba ito na covered ng copyright?
Can I answer that at a later date? I will have to take a look at it. At the particular situation, sorry.
Ito po.
Thank you, sir, for your answer. It's medyo complicated nga po yung question na yun eh. So it's difficult to answer because of the many circumstances involved.
Yes.
Pero siguro po I think it would be related to something like if you are on YouTube and you're doing a cover song. Parang ganun po. Is this ano po implications nito on
Yes, if you are on YouTube and you're doing a cover song, ang magiging answer doon, the general rule is that there is still a copyright infringement. Why? Because ito yung rights, di ba, na exclusive right of the copyright owner. In the case of a cover song would be the composer of the music. And part of the right would be the right of other communication to the public, which is that on YouTube or other platforms. So it's a violation of that right and therefore meron pa ring copyright infringement. So bakit wala kayong nababalitaan for some na dinidemanda siya or hinahabol siya for copyright infringement? Well, sabi ko nga, ang offended party in copyright infringement is the copyright holder. So nasa sa musikero or composer of the song whether or not habulin niya yung tao for copyright infringement. But just because walang humahabol sa kanya does not mean that no violation has been committed. Yes, that's the short answer to this.
Thank you, sir. Am I correct, sir, to state that one of the big factors why there's copyright infringement is because of the fact that this is YouTube. It's made public. The content is made public. Therefore, it's a big factor in considering copyright infringement. Pero for example, if it's just a video made available to the school lang itself, would the circumstances change?
Would the circumstances change? For teaching purposes, I think it should be allowed for teaching purposes. But take note, the provisions of the law on fair use specifically mentions instances, even for teaching purposes, dapat for teaching purposes talaga siya. So there must be a justification, and the use thereof must only be to an extent necessary for such purpose.
Thank you, sir. And also, sir, since our DepEd teachers are themselves content creators, maybe you can give them, sir, an advice on how to protect their original works. Is there an advice you can give, sir, to our personnel in DepEd who create content?
Meron namang available.
If it's not government work, sir, for example, if it's, I want to clarify, if it's not government work, of course.
Okay. Assuming it's not government works, there are various methods and technologies now that will allow you to protect your work. For example, meron tayong tinatawag na technological protection measures. For ano ba yung mga technological protection measures? For example, the use of a password to provide access to your PowerPoint presentation or perhaps to a document can be employed by the copyright holder to make sure that only those with permission from him and therefore will have the password can access the work. Or for example, for artwork and photographs, then you would have what you call as your yung mga use of watermarks, for example, which will now render the work unusable, for example, by another person without the proper permission. Of course, yung original nun nasa iyo eh. So whenever you publish it, then you can employ certain measures or certain steps in order to protect your copyright. And of course, even though it's not a requirement for copyright protection, it is always prudent to, for example, put a notice or a notification. And I'm clarifying, hindi ito requirement for copyright protection, but it might be good to remind whoever wants to use your work that it is copyright protected, and then therefore you should make it a habit to put, for example, the copyright mark and whoever is the owner of the copyright in the works. In the same manner that your painters usually put their signature at the bottom of their painting. So madami namang various measures by which you can protect your work. Ang importante doon is maprotektahan yung work nyo, and yes, because under the law, pag in particular yung mga TPE, technological protection measures na tinatawag, when infringement is done by tampering with the technological protection measures, halimbawa, para magamit niya, tinanggal niya yung watermark, ang provision ng law is that kung ano yung maximum penalties for first offense, second offense, third offense, yun ang ipapataw sa iyo na as infringer, yun ang ipapataw sa iyo na kaparusahan. Remember, like for example, first offense is 1 to 3 years. Sabi doon, whenever an infringement is committed by tampering with any of these measures, either technological protection measures or rights management information. Ang rights management information is example when you're typing a Word document, pag titingnan mo dun sa details niya, may nakatype doon na kung sino yung owner or creator of that particular document, when was it first created, when was it last edited, may mga ganon, di ba? So, whenever infringement is committed by tampering with any of this, ang sabi ng batas para maparusahan sila, maximum of the penalties provided under the law. So yes, the best way is to protect your work through technological means, since technology na rin lang.
Thank you, sir. Thank you for giving us that information. Sir, one of the current efforts today of the DepEd is to localize or indigenize po yung materials, meaning from regular materials, it becomes a derivative work.
Yes.
It's translated into local dialects or into or based in or made indigenized, made more understandable to certain communities, indigenous communities po. What would be your advice po regarding these kinds of alterations of copyrighted work?
I think are we referring to works that are owned by the indigenous people?
That could be another question, sir. But
sige. For
I'm
use,
pertaining copyrighted work, then translated po to another dialect.
Okay. Copyrighted work, of course, the general rule is the copyright owner or the copyright holder has the right to transformation or adaptation or any derivative work. So ang ibig sabihin nun, when you want to translate it into the local dialect, then hindi mo dapat hina-hijack kasi subsisting pa rin yung right in the original work. So therefore, ang advice doon is seek permission if necessary.
Sir, since you also mentioned it, yung sa indigenous communities po, yung copyright po nila, what can you also say about it, sir? It's also one of the DepEd concerns.
Yung traditional cultural expressions na tinatawag is at least in the Philippines is not something that is covered now by the copyright law. Why there are certain elements there are certain elements in copyright that are not applicable to traditional cultural expressions. Unang-una, who is the author of the work? If it's something that has been passed from one generation to another, it might be practically impossible to pinpoint who the author of the work and from whom permission must be sought. So yung TCE is an evolving field. Well, in some countries, they wanted to protect this as under the copyright law. In some countries, they provide sui generis protection. Hindi pa settled ang regime for the protection of traditional cultural expressions. Pero we have a law that provides that whenever ephemeral law, whenever work which belongs to the community in general is to be appropriated by somebody, then I think there are certain procedures provided in another law that must be complied with in order to seek their permission.
Thank you, sir, for clarifying on that matter. It's really informational. We appreciate it. We appreciate the information, sir. Another question, sir, with regards to that relates to work in DepEd is that if for example, personnel uploaded material that is considered that may have infringed on the copyright of another, who would then be liable if for example, this is done by a DepEd personnel?
That's why it's important to check, especially when when you are using the official pages of the DepEd, because that would fall under letter C, while he may not be the direct infringer. DepEd, I mean, is not the direct infringer by uploading it on the official website of the DepEd. Then I think there can be a liability in terms of C, contributing to the commitment of the infringing act. So importante talaga yung role ng QAs and even auditors. I don't know if you call that auditors then, yung nag-check to make sure that kumbaga ito yung mga guardians nyo to make sure that no intellectual property rights are violated in the process of producing these materials. So very important, especially when if it is uploaded on an official site or sanctioned yung action na yun by the DepEd in general.
Thank you very much, Director Cuyo, for answering that. Yeah, yes, Director Orebia.
Yes po, okay lang po ba, Director Emerson, yung kaninang tanong? Kasi ito, medyo klaro na yung facts na nag-follow up kasi siya na question. Ang kanina pala, bale, ang public school teacher, for instance po, ay, she lifts a lesson from a book, teaching siya a lesson on a book. Tapos, flinash niya yung book sa screen. Kasi binideo siya, for instance. So, habang nagtuturo siya, flinash niya yung book. Ang book kasi dito sa amin, di po ba yung textbooks? They have copyright kasi we procure them. Opo. So, yun. Tapos, syempre, kung flinash niya doon sa video, so na-take niya, naisama yung book parts. And then, if that would be uploaded online sa internet, paano po ba yun? May issue po ba yun sa infringement or kasama pa siya sa free use?
I think kung flinash lang niya yung book, if that's what you're referring to, wala namang infringement doon unless every part of the book kumbaga nakasama na doon sa video. So parang it's as if a substantial portion of the book is being publicized, no? So I think wala naman if it's just in the matter or in the course of taking the video, nakasama siya na flinash niya, for example, a page of the book. I don't think that would be a substantial action for copyright infringement. There would be a substantial action for copyright infringement.
Okay po. Kung okay pa po,
ibang usapan yung pag madami na, yung kumbaga it's as if para mo na ring pinablish or dinidiscuss yung buong book, ibang usapan po yun. But if it's just incidental na flinash niya because that's the particular portion where the lesson is contained, then I don't think there's any issue at all in the particular case.
Okay po. Thank you po for that very informative answer. Ito po kung okay pa pong magtanong ako dalawa na lang po kung okay lang. Ito isa kasi for our deaf learners. In connection to the production of materials for the deaf, is it okay if the writer use herself or himself for the interpretation of the sign language than using other sign language videos? If in connection to the production of materials for the deaf, so it is okay if the writer use herself or himself for the interpretation of the sign language than using other sign language videos?
I'm not too sure about the particular specifics, pero ang intindi ko, merong writer na instead na kailangan niya mag-translate. Is when you say writer, siya mismo ang nagsulat ng story? Hello?
Wala po si Director Orebia. Maybe I'm assuming po yun po ang ibig niya sabihin.
Kung siya mismo ang nagsulat ng story and he wants to translate it into a sign language and he is knowledgeable into the Filipino Sign Language, there is no reason why I don't think there's any problem with that because he's the writer in the first place and he wants to translate it. As sabi natin, it's the copyright owner who has the exclusive right to make translations or adaptations of his work. Now, if it's somebody else's, my permission to translate it into somebody else, I don't think there is also an issue there unless there is an issue with the community. But I think that's not anymore a copyright. That would not be anymore a copyright case.
Thank you po, Director Kuya, for clarifying on that matter. I believe Director Orebio mentioned another question, but I think we lost her for a bit. There's another question, sir, that if let's say a teacher indicates cites a YouTube link on her learning module, does it have copyright implications if she just uses the link and indicates it on a learning module? Or what? Since it's just a link, hindi naman siya actual video, and as you mentioned a while ago, YouTube videos they generate income by themselves. So wala, is there copyright implications?
If it's just a link, no. Walang copyright implication. Because ang nangyayari doon is when you click on that particular or you type in your browser that particular link, madidirect siya sa particular YouTube. I'm assuming that's the case. Then there's no copyright implication there. Unless the YouTube video is in itself infringing on the right of another.
Thank you, sir, for that clarification. Again, thank you very much, Director Kuyo, for answering all our questions. Our DepEd personnel, they are really interested in learning so much about copyright. There's so much interest and there's so many questions. Unfortunately, we would not have enough time to answer all of them. But I believe in general, you've answered most of them already. Thank you very much, sir.
Thank you.
We will turn you over, sir, to Joms for the next part, sir, of this webinar.
Thank you.
Thank you very much, Attorney Art Sioson. That's Attorney Art from the Legal Division of the Legal Service of the Department. Thank you very much to Attorney Emerson Cuyo, the Director of the Bureau of Copyright and Related Rights. This juncture, we would like to award this Certificate of Appreciation to Attorney Emerson Cuyo.
The certificate reads, the Republic of the Philippines Department of Education presents this Certificate of Appreciation to Attorney Emerson G. Cuyo as resource speaker in the webinar on copyright for the Department of Education personnel, held on June 25 to 26, 2020 via Microsoft Teams, given this 26th day of June 2020, signed by Undersecretary for Curriculum and Instruction, Diosdado San Antonio, and Undersecretary for Legal Affairs, Attorney Josephine Maribojoc.
Once again, Attorney Emerson Cuyo, the Director of the Bureau of Copyright and Related Rights from the Intellectual Property Office of the Philippines. As what we have said, they are not just experts in the field, they are the authority. Thank you very much, Attorney Emerson Cuyo, the Director of Copyright.
Thank you.
Thank you, Director Kuya.
Thank you.
There you have it, friends. As of now, we are 2,000 in the MS Teams platform. We are still 2,000. Okay. We have just finished in 2 days the webinar on copyright for the Department of Education personnel. We are sure that you have learned a lot and that what you have learned will be used in your workplaces. We'd like to know your impressions. So right now we are bringing you back menti.com. It's now time for us to bring back menti.com and open your browsers on your laptops, desktops, tablets, smartphones, or any device you are using now. Again, that's menti.com. All right, once again, it's menti.com and the code is 158251. That's 158251. All right, there you have it. We are now accepting your answers. The code is 158251. Just give us the impressions. You will be able to see there the phrase Day2 impressions. Just input a word that does describe your impressions and send it. And there we have it. We are welcoming back informative, enlightening, right, and happy. Surprising, we have the happy impressions for now. Kanina wala, no? And just give us that word, a word that should describe the webinar. They can be in English word, Filipino, or a noun, a verb, an adjective, an interjection maybe, or anything that comes in your mind right now that describe the webinar on copyright for the personnel. Lamang ang informative. All right, thank you for that impression. Once again, the speaker for this afternoon is Director Emerson Cuyo, the Director of the Bureau of Copyright and Related Rights from the Intellectual Property Office of the Philippines. So we have results coming in right now. We have 300 results as of now. Informative, very informative, and enlightening. It's the same results that we have generated in the impressions for day one. Superb. We can see amazing. We can see impressive. We can see great, revolting, fruitful. All right. Very hard, but interesting. A bit enlightening. Okay. So we'll just wait for our 500. Now we are, all right, we have reached 500. So it's safe for us to say that the top 3 results for the question Day2 impressions are informative, very informative, and enlightening. All right, let's have another menti.com, and this time the code is 6782 678-201. That's 678-201. The question is, if we would conduct another copyright webinar, what topic would you like to be discussed? For webinar 1, we discussed the introduction to copyright and then the limitations on copyright and plagiarism and copyright infringement. We will have other webinars on copyright because this is just the first leg of the webinar series. If we would conduct another copyright webinar, what topic would you like to be discussed? The code is 678-201. 678-201. We have results coming in. We have making modules about secondary use. We have referencing step-by-step, especially in citing references to avoid infringement and plagiarism. We have, okay, a lot of us are answering referencing. Okay, fair use have been discussed this afternoon. Maybe they would like to have deeper discussions on fair use, maybe a training. Music copyright. We are guessing that these are music teachers or Muppet teachers. Copyright software, whatever that may be. Okay, copyright among supplementary learning resources in a DepEd, or we call them the SLRs and the SLMs. More on copyright, so that means that a lot of us are wanting more discussions on copyright. Just as what we have mentioned earlier, this is the first leg of a webinar series. We also see results on YouTube videos of fair use. YouTube has been mentioned in the discussions by Attorney Cuyo a while back. Okay, copyright and plagiarism. Also, the Marrakesh Treaty. The Marrakesh Treaty, for those who are not acquainted, this is for the blind, or something to do with the accessible formats of the learning resources. We will also have other topics like the indigenous people's rights, or IP for IP, maybe in other legs of the webinar series. So there you have it. There are more results coming in, and maybe it's safe for us to say that a lot of you, or most of you, would like another copyright webinar. Okay. So fair use. All good things eventually come to an end. And since we are used to contextualizing everything, we will contextualize this saying as well. We are closing this very good and helpful seminar, but to do that, let us welcome on the platform the Director of Bureau of Learning Resources, Cebu Office, Engineer Raul La Rosa.
Distinguished speakers, participants, management team, producers, and the support staff of this webinar on copyright for the Department of Education, ladies and gentlemen, good afternoon. The legal knowledge and experiences on copyright and related rights shared by our speakers in this two-day webinar are very crucial in developing the text-based learning resources like the self-learning modules and supplementary learning resources that includes online, radio, and television, multimedia, interactive, and other formats that will be used by the learners, especially in this time of COVID-19 pandemic. The locally developed learning resources are quality assured. Thus, there is a need to orient the developers, evaluators, and managers to increase the knowledge on copyright and related rights. Having a well-founded knowledge on the legal aspect of the copyright law that includes the topics discussed, such as the copyright and related rights, limitations and exceptions for the education sector, and understanding plagiarism and copyright infringement will increase the self-confidence of the practicing personnel, thereby resulting to a better development and production of the text-based learning resources that will support the basic education learning continuity plan. At this juncture, the Bureau of Learning Resources and Legal Service of the Department of Education expresses its sincere appreciation to the esteemed speakers from Intellectual Property Office of the Philippines, IPOPEL. For Day 1, Attorney Jeremy John Bayaras, Chief, Bureau of Copyright and Related Rights. And for Day 2, Attorney Emerson Cuyo, Director, Bureau of Copyright and Related Rights. Thank you for sharing your expertise and valuable knowledge to the Department of Education. To the team, management team, producers, and support staff from the Bureau of Learning Resources and Legal Service, thank you for making this webinar on copyright a great success. God bless us all and keep safe. Maraming salamat.
That is Director Raul La Rosa, the Director 3 of the Bureau of Learning Resources stationed at the Cebu office of the BLR. So there you have it. We have finished the two-day webinar on copyright for deaf personnel. We are asking you to take the online evaluation of this seminar. We are providing you the link. The link is defed.in/copyright webinar eval. So it will be flashed on your screen. You can take a picture of that. You can jot it down. All right, and we will also make this the basis of giving you the certificate of participation. All right, once again, that's defed.in that copyright webinar eval. That would be the evaluation for the 2 days, not just for today, but also for yesterday. So again, defed.in/copyright webinar eval, capital letter C, W, and E. So please take a picture of that. At this juncture, I'd like to invite the production team or the people behind this webinar. So I'd like to invite the people behind the webinar to please come out on video, guys. So there, we can see Sir George, a producer. You can see Ma'am Bessie Agamata, our first speaker for the webinar, and at the same time overseeing the seminar as the Chief of the Learning Resources Production Division, the other half of the office that manage this webinar. Also here you can see is Mr. Joselito Asi, another producer and another senior education program specialist from LR Production Division. And Mr. Eric Labre, another producer and another specialist from the Learning Resources Quality Assurance Division. We also have our partners from the Information and Communication Technology, Mr. Genesis Fernando and Ms. Kathleen Isa Pandiola. And of course, from the Legal Service, Attorney Arturo Sioson, and from the Legal Division, Director Roan Orebia.
Hi!
Thank you, everyone. God bless.
So, on behalf of the Bureau of Learning Resources and the DepEd Legal Service, these have been your moderators. We wish you good health, everyone. Good afternoon.
Stop broadcast na.
Hello, ma'am.